Good afternoon and welcome to today's webinar, Cohabitation and TOLATA Property Disputes and the Dispute Resolution Toolkit. My name is Graeme Fraser and I am a partner and head of family at North London firm OGR Stock Denton. I'm delighted to introduce our guest speaker today, Beth Darlington, barrister and mediator practicing from 1GC Family Chambers in London. She specialises in property and family finance cases. She is recognised as an expert in applications involving cohabitees, regularly appearing in both the business and property court and the family court. She is the author of highly regarded practitioner texts, including Cohabitation in Trusts of Land, as well as being general editor of Cohabitation Law and Precedents. And yes, these are really serious tomes. Before I start, please do feel free to add anything you wish, either in the Q&A section or the chat, and we will either try to pick up the points as we go along or at the end. Beth, please can you go to the next slide?
Heard that expression somewhere, I think, before.
So as you can see, the demographics are consistently showing an increase in the numbers cohabiting in this country. And as a result, we are seeing a growth of inquiries, both in terms of cohabitants entering into cohabitation agreements at the start of the relationship, or when a property is being purchased, and separation agreements when the relationship breaks down. It is difficult to know how many of those cohabiting are likely to need legal advice. We do know that much larger numbers of children are born to unmarried mothers, and that there is a much higher amount of properties owned and occupied by unmarried families than previously. This results from the changes to family life over the last 40 years, where home ownership and starting a family are now steps taken along the road to marriage, as opposed to taking place after marriage. The difficulty here is that when the relationship breaks down unexpectedly before the couple marry. It is also generally accepted that the law is unfair to those who suffer relationship-generated disadvantage, very often women. By giving up work and looking after children, they can end up getting nothing if they have not made direct financial contributions towards the acquisition of a property. As cohabitation law reform, however, is not immediately on the horizon, we must consider the law as it stands now and what are the best processes for our clients. Beth, please could you go to the next slide? Well, before I turn to Beth to run through the dispute resolution options, what we can definitely say now is that running TOLATA cases in the family context is uncertain, risky, and highly expensive. If there are disputed facts, then going down the route of contested proceedings means a significant outlay on legal costs, with the risk that the loser will pay the winner. We know that in family cases, emotions run particularly high, but cases run under the civil procedural rules really don't synchronize well with what's known as the grief cycle that our clients go through. This is the cycle made up of the emotions experienced during the trauma of separation, namely denial, anger, bargaining, depression, and finally acceptance. A couple may well be at different stages of this cycle, and therefore emotionally triggered by different things. And this then reduces the chances of getting a settlement on fair terms in an efficient way if the process is not right for them. I'm now going to turn to Beth, who will run through the dispute resolution options.
Thank you, Graeme. I'd like to consider the dispute resolution options in relation to unmarried couples, as Graeme said. And these include, firstly, civil mediation, secondly, private FDRs or early neutral evaluation, and thirdly, considering arbitration. And what we thought we would do is introduce a couple of scenarios to illustrate how these different options might be best used. So in relation to the first one, civil mediation, we thought we would use an example where there's a purchase of a property in one of the parties' sole names, because in our experience, It's that kind of case that can often be perhaps the most difficult to establish a claim. And so in this scenario, a property was purchased in the sole name of Stuart, using proceeds of sale from his former property and a mortgage in his name. His partner, Janet, asked why she hadn't been included on the title, and she was told it was because she wasn't yet 21. She moved into the house, took his surname by deed poll, and subsequently gave birth to their first child. And when she first moved in, the house was dirty and dilapidated. She did a great deal of work to the house and garden. She stripped the wallpaper in the hall, painted the woodwork in the lounge and kitchen, painted the kitchen cabinets, painted the brickwork in front of the house. She broke up concrete with a 14-pound sledgehammer. It might be that these facts are starting to sound familiar, and that's because it comes from the memorable case back in 1975 of Eves and Eves. And I thought we could use this as a particular example because I think it's fair to say, Graeme, I think you probably agree that even though it's over 40 years ago, the law really hasn't, in sole name cases, moved on a great deal. Would you agree, Graeme?
Yeah, that was the interesting thing when you were putting these together, Beth, because we often take 1984 as being the Burns and Burns point, but the fact that you found a case going back to 1975 shows just how backward the law is, that we haven't actually changed in, 46 years. It's quite incredible.
Clearly, there've been some developments with Stack and Dowden, but I think in sole name cases, this is often a scenario that we still get presented with today. So having broken up the concrete with the sledgehammer, she put the pieces in the skip, then demolished a shed, put up a new shed, and prepared the garden for turfing, and had another child. After that, Stuart left for another woman and moved out. And she's surprised and distraught to receive a letter before action from his solicitor stating that she's no right to remain there and that she should move out within the next 6 weeks. And unless she agrees to do that, an application will be made to court within 14 days seeking her removal from the property. And so she comes to see you the next day for advice. So Graeme, what would you initially advise Janet in this situation?
I was just going to say before talking about that is that what you've just described in terms of letter for action, I've seen quite a number of those over the past 12 months, despite the fact that we're in a pandemic. And therefore, this style of letter are ones that we genuinely see today, which I suppose is quite shocking. It must be very frightening for anyone who receives them. So, I mean, when Janet comes in for advice, the first meeting is incredibly important in terms of the information that needs to be obtained at that time and the advice that needs to be given. The starting point is always to first check the land registry title, including the conveyance, which nowadays is termed TR1 or the TP1. If the title is not conclusive, then instructions must be taken at that point to establish whether there are implied trust claims, mainly constructive trust, but also having in mind proprietary estoppel. And no, because we're relatively short on time, we're not going to go through the definitions of those today. Very importantly, if there are children, there may be claims based on Schedule 1 of the Children Act 1989, and it's very, very important to check for eligibility. A check should also be made as to whether the couple were formally engaged. And as with all cases at the entry point, it is important to screen for any domestic abuse issues. And this has been a particularly important consideration during the pandemic. And I have to say, sadly, it's been a consideration on the cases that we have seen. In cases where a beneficial interest is provable, we should also consider applying for an occupation order at an early stage. And underpinning all of this is the importance of understanding the family dynamic and discussing the process that is most likely to work for Janet. Back to you, Beth.
Thanks, Graeme. Thank you. So in a civil mediation, as opposed to family mediation, what should you expect? So the parties agree to jointly instruct a mediator one party typically putting forward a number of options of accredited mediators from which the other party will choose one, or there'll be an agreement reached anyway about who the most appropriate mediator is. And a letter of instruction is sent to that person. And then an important agreement to mediate is sent out to the parties. And that will usually include the matters in dispute, where and how the mediation is to be conducted, that someone will be present with full authority to settle, directions for filing an agreed bundle, which in civil mediations is perhaps surprisingly often very brief, just the essential documents and a position statement, which again is often brief, with any legal authorities relied on. That the mediation will be conducted on a without prejudice basis, and that it's to be kept confidential and not recorded if it's conducted by remote means. The agreement will also provide that the mediator will not disclose any information or document to the other party without specific authority to do so, the time, place and duration of the mediation, that no person other than the parties, their representatives and the mediator shall attend without the consent of all the parties, and that any person attending to sign should sign the agreement to mediate, signifying their agreement to the confidentiality clause. The terms of any settlement agreement may be set out in a written document prepared by the parties or their representatives, and the costs typically to be borne equally by the parties. And that can often be a sensitive issue. I think, Graeme, we had a discussion about this, and whilst parties are often quite happy to instruct and pay their own legal advisors, that might be more of an issue in terms of the mediator. Would you agree, Graeme?
I would, and I think the issue is building trust, and building trust at an early stage. So building trust with your own legal advisor, we know that people do tend to trust their lawyers because they hire them and they pay them and they retain them and they build up a relationship. But when someone is added in to the mix later on, it's quite difficult to build trust, and also because the mediator is a neutral. So there is sometimes a suspicion, oh, this person isn't on my side, and therefore I think developing the relationship initially with the mediator is incredibly important, and a good mediator will take the time to meet and understand the parties, and I think the mediator is then doing their job really well when they do that. But I have to say that the key to all of this is in the preparation.
Yes, I agree. So moving on just to look at some more practical points then in terms of civil mediation. It can be arranged relatively swiftly, subject of course just to availability. As I've said, the bundle is usually relatively brief, as are the position statements, which again assists in being able to organise them quickly. In practice, although some mediators will have an initial session, joint session between the parties, or perhaps just their legal representatives, other mediators dispense with that, taking the view that it simply raises the temperature, only to have to then bring it back down again for the parties to then effectively begin negotiations. It depends upon the mediator, but in some cases, particularly I would suggest acrimonious ones, it might be better not to have that initial session. If a third party wishes to attend, in practice it would be a good idea to raise this with the other side and the mediator beforehand. It can be helpful for a party to have someone with them at the mediation to discuss matters with. That can often assist, in my experience, if there's somebody there who's a trusted person for them to speak to. But it's better to have their involvement clarified beforehand, if at all possible.
I was just going to say on Beth that is particularly important. The preparation is particularly important during the stay-at-home restrictions and during the pandemic, and we suspect that a lot of mediations will remain remote. Actually, we have to think about the background to this, that people often live in shared accommodation. And then there's the issue of people feeling that they need that support and that sort of bubble, as it were. So getting that right, getting the tension of that right, is all about agreeing ground rules, and it's best done beforehand if you can, rather than at the time, because that can interfere with the time that you actually need to invest in the mediation itself. I'm just picking up one of the questions that's been flagged up, which is, can you use family mediation? Well, yes, of course you can. And family mediation also has the benefit of being all issues mediation. So often that we see that where there are Schedule 1 cases in addition to TOLATA, but we're focusing in here on TOLATA cases at the moment.
Yes. Thank you, Graeme. Yes, so on that point, just going back to whether you have a third party there with your client, I think that there are different considerations that apply when it's being conducted remotely than if you were in person, perhaps. And so it's more important because you simply don't know who might be lurking around in the background to have that absolutely clear. But remote mediations do have, in my view, a number of advantages. Particularly in acrimonious cases, or perhaps even where there's been domestic abuse. And as long as the mediator's made aware of this, they can take steps to set it up appropriately. And that could include ensuring that the parties arrive at staggered times so that they don't accidentally bump into each other in the waiting room, and they can be put into their respective rooms on Zoom so that they don't have to see each other at all. During the course of the day, whether it's conducted in person or remotely, it's important to ensure the client has plenty of opportunity for breaks and refreshments where necessary. And typically civil mediations last a day, but it's not uncommon for them to continue after typical working hours.
Yeah, I was just going to comment on that, that recently had a case where I had the experience of seeing my client all hours of the day, including at the end of the day in her dressing gown, drinking a cup of cocoa, getting ready for bed, when the lawyers have been busy working on the heads of agreement. Now, I have to say that that's a marked change to what used to happen previously, where we'd all go down to, when I'm work in London, so we all go down to the centre of London for a 15-hour session, and we're worried about when we're going to get home on the commute. So there are a lot of changes. It's really a lifestyle change for people. And on the one hand, you've got the intrusion into your own home of lawyers and very serious events, but on the other hand, you've got your sort of your comforts of being at home. So this is going to take a bit of time to bed down, but we know the landscape is changing, and I think it can be said that it's here to stay, and it's a very important type of process.
There are certainly advantages from, like in many areas of conducting mediation remotely. So just moving on then to look very briefly at hybrid mediation. And this is a relatively new model where civil mediation borrows aspects from the family mediation approach. And that might include, as we've just mentioned, a civil mediation typically lasts one day, and you stay there until either the heads of agreement are concluded, or in some cases, concluded agreements reached. And it can go on to the early hours, but perhaps in a case, a TOLATA case, and particularly one where there might be a Schedule 1 application for the benefit of any children, then it's worth considering a hybrid mediation where it might take place over more than one day. And also there would be safeguarding screening, and you might instruct a mediator who's got experience not just in civil mediation and perhaps property disputes, but someone who's also got experience in the family jurisdiction as well.
And just to comment on that briefly, hybrid mediation, we have seen that become much more popular as a dispute resolution tool. It may be something to do with the fact that there has been a reported decline in recent years of the uptake of what we call the more purer forms of collaborative law, whereby the courts whereby you were locking lawyers out if you went to court afterwards. that model is changing. So it'll be interesting to see how that develops. Also, just to answer one of the questions that's been raised, and I did say this in my introduction, but Beth is a mediator, just to clarify that.
Thank you. So moving on now to look at a different scenario and consider, in the context of that, first of all, private FDRs and early neutral evaluation. And in this scenario, we're considering the purchase of a property in joint names. We took the view that this type of case might be one that might be more perhaps likely to end up in court, and that might lend itself to this form of resolution. So in this scenario, properties purchased in the joint names of Patricia and Leonard in 1985, no express declaration of trust, and the deposits paid by Patricia and the remainder via a mortgage which she pays, together with the bills, and Leonard pays for some improvements to the property. So they split up in 1993. Leonard makes no further financial contributions. They cash in a joint life insurance policy and divide the proceeds, which enables him to purchase his own home in 1996. And then some 10 years later, he seeks repayment for his share of the property. And she argues he's not entitled to 50% in the circumstances. Again, if you're thinking this sounds familiar, then of course these are the facts in Stack and Dowden. And again, it's right to say that often in joint names cases, you do have quite a significant length of time, often between the time when the parties separate and when they come to sort out actual ownership of the property and deal with sorting out the title of that. So we thought it would be a good one to use. So Patricia and Leonard are able to resolve their differences, and she issues proceedings in the county court under TOLATA, seeking a declaration as to the size of the beneficial interests. He counterclaims, seeking a declaration the property is owned 50-50 and an occupation rent. So it's listed for a CMC, a case management conference. We've not included a costs and case management conference in this scenario because I think it's better to avoid that if you possibly can. But the parties are keen for there not to be any delay and for the matter to be considered by someone with particular expertise in this area. So they agree to stay the proceedings on the basis there will be a private chancery FDR, because this is a TOLATA case in the county court, so strictly speaking, I think we should call it a chancery FDR. It makes little difference whether you call it chancery FDR or just FDR. And so they agree that the short directions hearing be timetabled by the court to be heard shortly after the private FDR. And they agree a direction that they'll both attend the private FDR and not seek to adjourn it unless by way of court application.
I was just going to say, Beth, that in terms of the example you picked, I think it's very apt because I have to say that I don't think that the precedents in either Stack and Dowden or Jones and Kerner are necessarily deterrent to people having disputes, particularly about quantification, because I don't think either case can say that it's a definitive answer what the split will be. So it doesn't surprise me that a lot of these cases end up in court or the prospect of there being court proceedings.
That's a very good point, Graeme. There's very little guidance even now in terms of quantum. It's very difficult to advise with any kind of certainty about the size of any interest. So in a private chancery FDR or early neutral evaluation, what can you expect? So chancery FDRs have developed following the very successful FDR model, which family practitioners will clearly be familiar with in finance cases over the past 20 years. And similarly, private chancery FDRs. And private FDRs have been consistently recommended by the judiciary at its highest level as a form of dispute resolution. the reform really of ENE, early neutral evaluation, in which an independent third party expresses an opinion about a dispute or a discrete aspect of it, and they are without prejudice, and can be particularly suitable where there's an issue of law or the law isn't clear, as in TOLATA cases. So in a private FDR, a trusted third party is appointed to act as an evaluator in the same way that a judge would in a court FDR, and that person may be a solicitor, barrister, or retired judge. No additional qualifications are required. So it's quite interesting to note there that the FDR evaluator doesn't have to have any particular qualifications, simply to have the expertise and reputation in that area. And that's different to mediation or arbitration.
And possibly quite difficult to find, Beth, actually, in this particular area of law.
Maybe, yeah. Moving on. So just to mention Court of Appeal case of Lomax and Lomax. In that case, interestingly, it was Lord Justice Moylan, obviously a family judge, in an Inheritance Act case, held that the consent of the parties is not required for the court to exercise its discretion under the CPR to order an early neutral evaluation. So where one party didn't want to submit to an early neutral evaluation, the court did have the power to direct them to do so. And court in that judgment drew a particular analogy with the successful FDR procedure in the family court. And although it didn't specifically refer to whether the same approach applied to FDRs as it did to ENE, I would suggest that as an FDR is effectively an early neutral evaluation, but with the tribunal assisting with the parties' negotiations, with the process of the negotiations, the parties returning to seek the opinion of the evaluator throughout the course of the session. The only difference is that they can't be compelled in an ENE to disclose without prejudice offers, but I would suggest that nevertheless the approach in Lomax would apply to an FDR in addition to ENE. It's a bit of a technical point, that one, for those who are particularly interested in this area. But moving on to look at some practical points in terms of private FDRs. So the evaluator's role is different to that of a mediator, in that they've been invited to give an evaluation of prospects of success and possible outcomes at final hearing, taking into consideration the law. And as with selecting a mediator, the usual approach is for one party to suggest a number of names and then a person to be selected from that list. A list of London private FDR judges was put together last year by Simon Bruce of Farrer & Co, which I think is still available on social media if you're interested in finding that. And I would suggest some ideal qualities of an evaluator include empathy, patience, self-assurance, clarity of thought, ingenuity, and stamina. So, Graeme, I don't know if you know anybody who's got any super person who's got all of those qualities.
I was just going to comment on that I would probably substitute the word aspirations as opposed to qualities. I think it must be difficult to show all of those at the same time, but obviously those are the attributes that people would like to have. Just want to raise a question that I wonder if you could answer, Beth. It just come up in one of the Q&As. Is it possible is it right that a court can actually order civil mediation, or is that a purely voluntary process at the moment?
Civil mediation, as I understand it, it is only technically ENE, and I would suggest also FDRs, but not mediation. hope that deals with that question.
Thank you.
So just continuing with some practical points about private FDRs. It wouldn't be appropriate for an evaluator to subsequently act as an arbitrator. It's suggested that although there's no requirement, unlike mediation or arbitration, for the parties to enter into a formal agreement with the evaluator in respect of the private FDR, it will be best practice to do so. And it may be possible to reach agreement in respect of certain issues at a private FDR, leaving the remainder to be dealt with at arbitration.
Now, I was just going to really comment about the place of private FDRs, because what we have seen in the last number of years, possibly partly pandemic related, but also because of the court stretched resources and just because of the success of the process. But we do know that private FDRs are having quite a high success rate and uptake in financial remedy claims. And I think they should work quite well in cohabitation TOLATA and Schedule 1 claims. And I say the key to this is picking the right private FDR judge, which may not be an easy thing to do. But it means there's an opportunity for a private judge, often specialist counsel, to give full consideration of a day to the case and provide a neutral evaluation that helps the couple to settle, rather than the couple having a feeling that any decision needs to be imposed on them. And I think it's just this sort of general charge towards the trial and getting a decision that may just be really, really unhelpful. And actually having that time and space and hearing from someone who talks in a calm and measured way may just be the thing that gets these cases to settle.
Thanks, Graeme. So moving on finally to consider arbitration. So in our scenario, the private FDR resolves some of the issues, but not all. And Patricia and Leonard decide that they would like to go to arbitration for the following reasons. They'd like to have their case dealt with in private rather than in open court, because of course in TOLATA cases being in the county court, there'll be an open court and can and quite often do end up in the press. To avoid directions hearings and costs budgeting, which is in my view always nearly always a good thing to avoid the harsh sanctions regime under the CPR. And they want to choose their own expert but independent tribunal. They want to save on costs and time. They want a timely award after the hearing, and they want the certainty of an award given by an arbitrator with only very limited grounds of challenge. In contrast, Haley and Haley in the Court of Appeal recently held that in respect of finance cases, in general terms, the general grounds of challenge of appeal apply, but that certainly at present does not apply to TOLATA. So there's still only very limited grounds of challenge to an arbitrator's decision. So of course they could have gone to arbitration had court proceedings not been issued or at an earlier stage in the process. So what to expect from an arbitration? TOLATA cases are covered by the IFLA rules, along with financial remedy matters and Inheritance Act cases. And the Family Law Arbitration Scheme is administered by resolution on behalf of IFLA. And the parties choose to instruct an arbitrator who will have undertaken training with the Chartered Institute of Arbitrators and be a member of that body. So the proposed arbitrator is likely to want a pre-engagement discussion with the parties, which helps build trust, confidence and engagement with the process, as we've said in relation to the other forms of dispute resolution. And an arbitrator is consistent. Unlike many court cases in the county court before district judges, you can often end up before a different judge from hearing to hearing, unless it's of course expressly reserved to the same judge. Graeme, I don't know if there's anything you want to add at that point.
Well, just to say that I think all the reasons that you've listed on the previous slide are really exceptionally good reasons, because we've seen what a straitjacket it can be when you get into TOLATA proceedings. Cost budgets are a nightmare to do. They take a long time. there's a lot of aggravation involved with court, a lot of hanging around, and this is just such a streamlined process. And I think there's just a lack of knowledge of just how useful it is as a process, particularly when you're dealing with specialist areas of law and sort of finite areas of dispute. So I really can't understate the benefits of using this process.
Thank you. Just carrying on then in terms of what to expect. If you decide to instruct an arbitrator, the parties enter into an IFLA form R1FS, and that refers the matter to arbitration. And the nature of the dispute is set out on the form, and it's important to capture the dispute accurately because that bestows jurisdiction upon the tribunal. In TOLATA cases, you may need to think about amending that form in two respects. Firstly, in respect of passages that refer to requiring the consent of the court, because you wouldn't need that in a TOLATA case. And also in respect of the no order to cost as to cost principle, because usually in a TOLATA case, costs would follow the event, so you might need to change that provision. It's a binding agreement to arbitrate within the meaning of Section 6 of the Arbitration Act. And a letter will be received from the chosen arbitrator accepting the appointment and inviting submissions as to the appropriate procedure, and a preliminary meeting may be convened. And then the arbitrator will then give directions, setting a timetable, including disclosure, witness statements, with the consideration of whether pleadings might be necessary. But that's the procedure that takes place, similar to as you would get in court, but perhaps without the same level of formality. And then just some practical points in terms of arbitration. The arbitration is effectively a private court, as I said, in terms of procedure, less formality, the arbitrator taking more of an inquisitorial approach than the court. Any communication with the arbitrator must be copied to the other side, and the arbitrator will not communicate with only one party ever. Where possible, you should try and narrow the issues and reach agreement with the other side, narrowing the issues then that the arbitrator has to determine saving time and costs. As I've already mentioned, Haley and Haley concerns financial remedy cases, so there's limited grounds of appeal. Another advantage of arbitration is that at any point the parties can communicate with the arbitrator on notice to the other side, but because of the nature of it, it's not like if you were in court, where if you wanted to seek the guidance of the court on any point, in most cases you would need to put an application in. So with arbitration, you can easily communicate with the arbitrator. And also in TOLATA cases, particularly where there's Schedule 1 application for the benefit of any child, it can avoid jurisdictional conflicts that you might otherwise get in court between the family and the civil cause. And you can appoint an arbitrator with experience of both. And if the parties want it, then arbitration brings certainty and finality, which can be an advantage.
Thank you, Beth. And I was just really going to say about that my experience as a practitioner using arbitration in TOLATA cases has been really, really positive. The arbitrator operates proactive case management. That's helpful in improving efficiency. Costs are a big consideration for people in these cases, and narrowing the issues does speed up the chances of agreement anyway, or achieving the outcome. And it's a humane way of trying to deal with these disputes. When I referred to the grief cycle at the beginning, I do think that with a good arbitrator, it helps people get into the right place. And it's never easy having to resolve a dispute anyway. And as I've said, I think it should always be considered when trying to determine a specific point. That could be, in this context, working out a clause in a disputed clause in a declaration of trust or cohabitation agreement. And it's often in the transactional work that we see the reference to referring matters to arbitrators. So I think with the increased uptake of declaration of trust and cohabitation agreements, which I have to say I've seen in the last couple of years, I think we will see it growing anyway as an area, as a process for this. Well, I think that actually brings us to the end of today's webinar. And I'd like to thank everybody attending very much for their time, and also Beth for her expertise and talking to us today. Just to say that we will be running another webinar on Friday the 23rd of April at midday, when at that time we will be talking about divorce and financial planning, and our guests on that occasion will be Claire Heppenstall of 1GC Family and Helen Howcroft of Equanimity IFA. So thank you very much for your time today, and goodbye.
Thank you.